All right, well, welcome everybody. My name's Tony Maida. I'm a partner at McDermott, Will & Emery and one of the co-chairs of our regulatory and compliance practice. Very excited to be here today with my good friend, Jackie Baratian.
Well, thank you, Tony. I'm excited to partner with you here and hopefully we share some interesting information with you this morning. I'm Jackie Baratian. I am the Chief Compliance Officer at Ascension, and Tony and I go way back in time, even back to our time at the OIG, and we see some of our former colleagues here today, so that's exciting. So I'm going to go ahead and jump right in. Hopefully the slides will cooperate. So this is what we're hoping today to accomplish. So in short, really want to do like a high level enforcement recap, some trends, some notable settlements, and some case law developments. Also want to talk about how the Stark Sprint rules have impacted physician contracting and compliance monitoring, get into some best practices and takeaways, and then how are the value-based rules actually being used. When we put our slides together, we had to laugh because we knew we had just an hour and we realized we had way too much information. So just encourage you, if you haven't seen it before, to check afterwards. There is a rather large appendix, and in the appendix, we've included some interesting recent OIG advisory opinions, some information on value-based care, and also some information on AKS safe harbor changes. So I'm going to go ahead and jump us in. If we have time, we do have 3 hypotheticals, but we'll play that by ear as to whether we can get to one or all 3 of them. All right, I'll turn it over to you, Tony.
All right. So I'm just going to do a brief sort of enforcement recap because it starts to show and to get into sort of what is to come from what has happened in the past. So enforcement trends, as everybody should know, the False Claims Act has really become the healthcare fraud enforcement statute. It is the primary purpose for this statute at this point, based on the recoveries that the government has received. It sort of spiked last year at $5 billion. The interesting part about this is it's almost the entirety of recoveries under the False Claims Act. And the AKS anti-kickback and Stark allegations, but more so anti-kickback allegations, are really the primary, I'd say the majority of cases almost have some level of anti-kickback allegations associated with them. So we're seeing a huge number of anti-kickback cases, and that's a trend that has been going on for some time, but I think it's going to continue into the future. The other graph that I think is interesting is the number of just the number of cases, complaints, cases that are filed relating to HHS programs. And as you could, the sort of green bar shows the cases filed by relators, and the smaller blue bar, which is not entirely easy to see, are cases that are filed by the government without a relator. And the vast majority, this sort of slide shows that there's, for the last 10 years, we've seen, at least 400, if not 500 cases filed every single year related to healthcare programs. We've also seen the government increase the number of cases that they file independently of relators. And I think that's an interesting trend that was not present in previous years, where you see that really almost all of the cases were filed by relators. So we're seeing DOJ take, and I think this is the result of additional resources and focus on DOJ in terms of bringing actions on their own without a whistleblower counsel. Some notable settlements, a lot of, obviously for anti-kickback statute, a lot of these cases involve relationships with physicians. Some of these cases, if you were at Bob's year in review yesterday, you will have seen some of this already, but I will provide it to you today just in case you didn't see it yesterday. Pods are in particular have been a sort of a long-standing focus of the government. There was an interesting settlement right before trial over a pods case, but there also was a settlement related to a physician and his 2 pods that followed several years from a settlement with the hospital that also purchased the devices from the pods. So we're seeing here the government looking at both the hospital purchaser as well as the physician and the pod, sort of both sides of the kickback transaction, if you will. Physician consulting, obviously financial relationships with physicians are a big portion of what AKS enforcement is about. these are examples, not just to show that there are always settlements. I mean, here there are two cases where DOJ filed a complaint, presumably because they were unable to reach an agreeable settlement with the provider. One with the manufacturer regarding consulting payments, where the allegation was little or no work was done, but it's not. And I think a lot of times physician consulting is associated with manufacturers, but the second example of a SNF and home health agency shows that there's also the financial relationships with physician consultants and medical directors sort of go beyond the manufacturer context. And then obviously the big settlement that the $900 million, I think is notable because DOJ sort of declined that case originally, and it was originally filed in 2012, which shows that these cases can last a very long time, and that relators have been increasingly pursuing cases after DOJ has declined. And there's been a fair amount of litigation around the meaning of declination of DOJ declination, in particular around where DOJ has moved to dismiss cases that they don't believe should be pursued. And those cases, that's a matter that's pending before the Supreme Court now.